Hello everyone, welcome to Court with Krissy. This reminded me of Mary Kay Letourneau, but behind bars. This guard was in a position of power, and she's going to prison. Here's her plea and sentencing. I hope you like it. Court with Krissy is now in session.
And ma'am, if you can come right up to the podium there, please. We're on record in People versus Jennifer Palmer, file number 255413. If I can counsel, please.
Sierra Coke on behalf of the people.
Jesse Williams representing Ms. Palmer is present to my right. We were intending to, the resolution of this case is if Ms. Palmer pleads guilty to MCL 750.520C subsection J, that's criminal sexual conduct in the second degree, a C-grid felony with sex offender registry requirements. People are going to dismiss all other counts. And our intention was to place the plea on the record today.
Okay, and that's the 15-year?
That's the 15-year.
Ms. Coke, is that a correct statement of the plea offer?
It is a correct statement of the plea
It's a
offer.
25-year. Oh, 15-year.
15-year penalty, 25-year registry.
Yeah.
And Mr. Williams, would you be prepared to question your client?
I could, Your Honor, I could do so.
Thank you. Ms. Palmer, have you had an adequate opportunity to speak with Mr. Williams about this plea agreement?
Yes, sir.
Okay, and is that how you wanted to proceed today?
Yes, sir.
Here's your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. Lower your hand. Ms. Palmer, are you currently on any kind of probation or parole?
Yes, sir.
No, she's
Oh,
not. She's not
sorry.
bond, Your Honor.
Fine. Sorry, Your Honor.
That's okay. And you understand that by pleading guilty to the charge here of criminal sexual conduct second degree, the maximum possible penalty that you could face would be up to 15 years.
Yes, sir.
And you've discussed the registry requirements with your attorney. You understand what those are.
Yes, sir.
With that in mind, what is your plea to that charge today?
Thank you, Your Honor.
Right now, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you if you're at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. Any appeal would have to be by leave. That means you would have to appeals to hear your case. They said no, then that would be the end of any appeal. You understand?
Yes, sir.
Has anyone threatened you with anything that you plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Okay. Mr. Williams, if you would please confirm that.
Ms. Palmer, I've provided you the information in this case, correct? These reports and other things.
Yes, sir.
And on or about the aforementioned date in those incident reports, were you here in this county?
Yes, sir.
And which county is this?
Crawford County.
And you were in Crawford County because you were where? Were you at work?
Yes.
That's in Crawford County.
Yes.
And what was the name of the institution or place you worked at?
Juvenile Center.
And is that a correction facility?
Yes.
Are you employed there?
Yes, sir.
And while during the course of your employment, you engaged in a relationship, correct?
Yes.
The person was 16 years or older, correct?
Yes.
But he was also incarcerated in that facility, correct?
Yes.
And by default, that's a crime, you understand, correct?
Yes.
And even though it was consensual, you engaged in intercourse, correct?
Yes.
And that intercourse would have involved some type of penetration, penile, vaginal, mouth, some type of sexual penetration, correct?
Yes.
I think that wouldn't be sufficient. Your Honor.
Ms. Coe, do you have any additional questions?
No. Thank you.
Ms. Coe, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Williams?
None, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute, court rule, and the taking of this plea?
Yes, Your Honor.
Yes, Your
Ms. Palmer, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support that you are guilty of this matter. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date, time of that hearing. Before you leave today, you're going to meet with Mr. Haven from the probation department to set up a pre-sentence report. It's also important that you stay in touch with Mr. Williams prior to that hearing. Okay.
Yes, Your Honor.
Mr. Williams, anything further?
No, Your Honor, thank you.
Ms. Koch?
Senator, there was some issues with the dates. It looked like it was very gray whether the child was 15 or 16 when the sexual relationship started. I understand that her plea today, she indicated he was 16 during the penetrations, and we are waiting for a DNA test to determine whether the child she was fathered.
I would, we've taken a plea. The court, the prosecutor agreed with the court rules. Whether or not there's additional DNA evidence related to this incident is not of consequence to the plea process. The court rule requires a factual basis. We established a factual basis. The prosecutor did not object to the factual basis. The court asked the prosecutor wanted to respond to that. The prosecutor did not. So I'd ask that we just move forward and straighten this conversation.
Well, I guess I don't understand. Why are we talking?
Your Honor, normally because there was a sexual assault of a minor, we would revoke her bond immediately under 770.90. The statute she pled to falls within that statute, which is 520C. It's specifically listed under there, but because she said the child was 16, that's one of the requirements. I was just putting it before the court whether the court wanted to revoke her bond given her plea. It is very likely we'll be looking at a lengthy prison sentence.
I don't think, given the nature of the charge and the testimony, that the court is required to revoke the bond at this time. I don't. There hasn't been any other grounds raised for why her bond would be revoked in terms of she's violated it in some way. So the court will continue the bond.
Thank you.
You want us to stand here?
Please, yeah. All right, we're on the record now in People versus Jennifer Palmer. This is file number 255413.
Jesse Williams with Ms. Palmer.
Sierra Coke on behalf of the people.
All right, and I know council's aware of this, but I just want to caution council again. This case does involve a minor victim, so I'm going to ask everyone to refrain from using the victim's name during proceedings here. Victim can be referred to as either victim or by initials. This is the date and time set for a sentencing hearing in this matter. Ms. Palmer, have you had a chance to go through the pre-sentence report and talk to Mr. Williams about that?
Yeah.
And Mr. Williams, are there any additions, deletions, or corrections to the body of that report or the actual?
Did the court receive the risk assessment formed by Burgess' office? That was filed as an attachment. It should have been attached. So there's a risk assessment, and Your Honor, just to be frank on the way here, I remember that this court requires or requests the attorneys to file a memorandum on challenging OVs, PRVs. I'm sorry, I forgot. I mean, I'm just in different circuits and everything. Different. So I do have OV challenges for 10, 13, and 19. I think it's important. She actually went and had a risk assessment done by the Burgess office, which works exclusively with the youth sex offender program in Kent County, exclusively with that court. And it was important for the court to have that information. I don't know if there's time for the court. I don't know if you want to adjourn it, you want to review it. I don't know what you want me to do. I'm just asking.
I'm not going to adjourn because we're all here. We've got victims that are present, so I'm not going to adjourn it. I don't know.
I just texted Jeff. So this is supposed to be attached. Yes.
I'll make argument regardless. I'll make sure the court has that document shortly.
Okay.
But it's important, it's critical. If we did not send it, that would be a mistake by my office. So
Yeah, I don't know. All I know is given everything else.
You are, and I agree with that, so I don't know. That being said, where do you want me to start, Your Honor?
I guess first, I want to make sure that there aren't any additions, deletions, or corrections to the body of the report.
No, we're only making factual challenges to that, and correct, we're not asking the court to delete it, we'll just make argument on anything that's in the report.
All right, so your first challenge is, you said the OB10.
The OB10, and it's scored for exploitation, and I understand that as charged, because she works in a penal institution, that statutorily that's a logical argument. But as far as scoring, the statement from the victim is very clear that the victim engaged Ms. Palmer, sought out Ms. Palmer, and proactively wanted this to occur in the victim's life. So in scoring, I'm assuming the 10 points is for the youth or agedness. And the argument is that, but for the penal institution at the time this incident occurred, at least for the facts of this plea and the PSI, the victim was of consenting age. The victim would have been 16 at the time, as far as the factual basis of the plea is concerned. So, but for the penal institution, this wouldn't have been a crime. So the argument that the youth or agedness of the victim was exploited, I don't, it's not defined in the instructions. So I'm arguing that it shouldn't be scored in this unique instance.
And I actually considered making the argument that under OV 10, she should have been scored at 15 for predatory conduct. I read through the investigation that was conducted initially at Shawano, where the young victim indicated that there was no sexual assault. We have since had a baby that the DNA has proven to be, as of Friday, the youth child. I went back from the date of conception and it was 8 days.
Okay.
What I just object is the DNA is not part of the PSI.
Well, I mean, there's no question that the child that was born with this is the victim's child, correct?
I'm not arguing the DNA. I'm just saying it was never part of the record or for the purpose of this.
There's reference to it in the PSI. Sentencing hearings are not subject to the rules of evidence.
Fair enough. I just make the objection, Your Honor. Just
Yeah,
for the
okay.
record.
That's preserved for the record. But
Thank you.
that's cool.
When I did a backwards calculation from the date of the birth of that child to the youth's 16th birthday, it was the date of conception was 8 days after that juvenile turned 16. 8 days is when the conception of that baby is, if it's a 40-week period. I say that because I think this definitely should be scored for exploitation. We are talking about a 32-year-old woman who was a police officer, and then she was a Shawano worker. She had control over everything with this youth when he was allowed out of his cell, when he was allowed to use the phone, what privileges he had. She had complete authority over him. And I understand that he thinks he is not a victim because he was, 8 days after turning 16. But she certainly had every bit of age on him. I think the difference in age, the exploitation of her position clearly shows that it should be scored at least 10 points. Thank you.
All right, so the variables, the court has to score variables. The court has to determine that there are facts by preponderance of the evidence, in other words, more likely than not, or just tipping the scales one way or the other to support actually the scoring of any particular variable. The court can use information contained within pre-sentence reports, victim impact statements, police reports, sworn testimony such as that given at preliminary exams or other proceedings in making those factual determinations. In this case, the challenge is the OB10, which is exploitation of a vulnerable victim. It's scored at 10 points, indicating that the offender exploited the victim's physical disability, mental disability, youth or agedness, a domestic relationship, or that the offender abused his or her authority status. Looking at the case law behind OB10, it's not the mere presence of one or more of those factors, it's the exploitation or the use or the taking advantage of one of those factors by the defendant that allows for scoring of OB10. So in this case, I don't, it's not just that the victim was 16. It doesn't matter whether the victim was of the age of consent or not of the age of consent. If the defendant used that defendant's youth, regardless of how old he was or whether he was over or under the age of consent, if she used that youth and his status of being younger than her or a teenager in order to be able to exploit that victim or use that difference in age to be able to accomplish the crime, then OB10 can be scored. Again, abuse of authority status can also justify the scoring of OB10 where that authority status is used as a means of committing a crime. In this case, again, under a preponderance standard, the court finds number one, the defendant was in a position of authority over the victim in this case. I think it's more likely than not that she used that authority status, the ability to grant or deny privileges as part of her role at Shawano. And then I do think there's sufficient evidence reading through the PSI that she used the victim's youth, his willingness to engage in this kind of conduct. She took advantage of that to satisfy her own sexual urges in this case. So the court finds that she did exploit his youth, the difference in their age, that she did exploit her authority status more likely than not, and therefore the court finds there's sufficient facts to support a scoring vote 10 points, and the court will deny that challenge. Next one.
Thank you, Your Honor. OB 13, continuing a pattern of criminal behavior. It requires 3 continuous acts. I'm not certain what those acts are. She indicated that nothing occurred more than twice, and he indicated less than that. So that there's nothing factual in the record to support three separate acts for the continued pattern.
So
Reading from the PSI, where it says page 3 on the bottom, I'm just going to read the whole thing. She said she and EB had sex at least twice. She said they had sex in a cleaning closet. She worked a float position so she could move around. EB would manufacture a crisis, such as flooding a toilet, and she would have to go to the cleaning closet. While in the closet, she would face the door so she could watch for other employees. She would take down her pants and underwear and bend over for the intercourse. She confirmed it was penis vaginal. She said the last time it happened, he came inside her. She purchased a Plan B, but it did not work. When asked about oral sex, she said he went down on her for a few seconds, but she performed oral sex on him just before they had intercourse the last time. When I read that, there's at least 2 incidents of penetration. There's 2 different types of oral sex. Each of those is a separate type of crime, and all of them would count for OB 13. I think it was scored properly. Thank you.
all right, again, OB 13 applies to a continuing pattern of criminal behavior. In this case, it's scored at 25 points. And that is where the offense was part of a pattern of felonious criminal activity involving 3 or more crimes against a person. In this case, I read the PSI, I read it the same way the prosecutor did, which was there were at least 2 instances of penile vaginal intercourse, as well as 1 instance of the victim performing oral sex on the defendant and the defendant performing oral sex on the victim. Those crimes all need to occur within 5 years. It's clear this all occurred in a short period of time. Again, looking at this conduct standard, the court finds there's a sufficient factual basis to conclude that there were 3 or more sexual penetrations, felonious sexual penetrations that occurred. So the court will deny that challenge. Sure. Williams, what you said there was.
Yeah, but I'm not going to challenge OB 19 based off of the record so far. So I'm going to withdraw that challenge. I would ask the court to maybe reconsider after the victim speaks, OB10, but I'll just raise that for the record, and then that's the entirety of my challenges.
Okay, all right, thank you. Ms. Coe, do the people have any additions, deletions, or corrections?
No, Your Honor.
I did receive a victim impact statement earlier today. Have a chance to review that statement.
And I think victim ED should be on Zoom. He was moved last week, so we were chasing him around to multiple different people trying to get him here, but I think he's here. And I think Ms. Rios may also be present. She is the minor child's mother. She may want to speak. She was deciding today.
All right, Ms. Rios, I see we have brought you into this hearing. If you wish to make a statement, did you wish to do that today?
Your Honor, sorry, is this the victim's mom?
It is.
I thought it was the victim. Can I just make the proper objection for it?
Let me find out if she wants to speak
Okay,
first.
all right.
Ms. Rios, did you wish to make a statement today?
Yes.
Okay, 1 second, please, Mr.
Your Honor, I would just object under the statute itself. It allows for the victim to speak, and it also allows for a family member to speak if the victim's under 18, but to speak for the victim. But in this instance, the victim's speaking, so that it wouldn't be applicable. That I would just make that objection.
Your Honor, I believe, and I'd have to pull the exact spot in the statute. I actually went over this numerous times. Because he is a minor, the parents are considered victims. Because he is incarcerated, he didn't have rights until sentencing. So we didn't provide those rights, but we did work with his mother. I actually ended up calling the Prosecutors Association because everywhere in the Crime Victim Act, it talks about defendants being incarcerated, but not victims. So minor victims, I should say. So we treated both of them as victims throughout the whole case.
So my reading of the Crime Victims' Rights Act is that under these circumstances, both the victim, because he's a minor, would be able to make a statement along with a parent. I think there is an added layer here that the victim is currently incarcerated. I think all of that together, it's the court's ruling today that both or either can make statements. So the court will deny the objection. And Ms. Rios, now would be your time. Can you just, I already know this, but I want to make a record of it. You're the mother of the victim in this case, is that correct?
Yes, Your Honor.
Okay, and you may have heard this when I brought you in and made this statement at the beginning of the case here, but I'm just going to ask that you refrain from using your child's name here on the record, okay?
Okay.
And that's to protect his privacy. So please let me know whatever it is that you would like to state. I did read through your written statement that you submitted as well.
Okay. I'm really just in disbelief. Can you imagine your son being in a secure treatment facility and being sexually assaulted and taken advantage of? Can you imagine someone your own age having a relationship with your son at his young age right now and having a baby? It's just a nightmare, and it's became my reality.
Hello, this is JDF, and we have Mr.
He was
okay. Thank you. I'm just going to ask that the victim, young man, that the camera remain off. And once the mother is done making her statement, I will ask if he wants to make a statement. Please refrain from using the victim's full name here on the record, whoever just said that. Thank you. Ms. Rios, if you'd like to continue, I'm sorry about that interruption.
No problem. He was the youngest child at the Shuano Center trying to rehabilitate and work on his own issues. Instead, he was focused on you. You manipulated my son. You preyed on him. You were in a position of power that wasn't supposed to happen. You were trusted with all of these children to keep them safe and help them through the program. This is going to affect my son for his entire life. He doesn't think that he's a victim because he's a teenager that just got to sleep with a grown woman while he's locked up. A lot of people don't view it as bad as it really is because he's a boy and she's a girl. But the fact of the matter is, he was and still is a child. I don't know what to say now that DNA was established, because I really had a whole different message for you. But I don't want to sabotage any relationship with that child. It's to be in that baby's life. But you're really selfish.
All right, thank you. Ms. Rios, was there anything else that you wanted to say today?
No.
Okay, to the facility where the victim is, if you can unmute, please. All right. Do we have the victim EB present? I'm using the initials EB. All right. Young man, is there anything that you want to say here to the court for the sentencing hearing today?
No.
Okay. All right, thank you. Ms. Koch, anything on behalf of the people for allocution?
Now, the court has read through the PSI, is aware of all the facts and circumstances of this case. Obviously, we've talked about the fact that the DNA did come back on Friday and confirmed that this, I think he's 17 now, year old, is the father of Miss Palmer's baby. I'm not a paternity expert and she is legally married, so I don't know what will happen legally with that situation. But we now have this recommendation. The guidelines are 29 to 57. Frankly, I think Miss Palmer's behavior is pretty egregious. When I read through it, all of the behavior that went up to this and all the things she did, all the going to the room, the faking the accidents, everything that happened to get access to this young child. I know he does not think he is the victim. I know that by the time anybody admits sexual intercourse happened, he was of the age of consent. But this is just a terrible circumstance. Shawano is a secured facility. We're supposed to be able to send youth there. You know, he had a pretty violent history. I've dealt with this victim on several occasions since he's been at Shawano, so I'm pretty familiar with him. This is just a terrible situation. I'm not sure how this could happen in that type of facility. There's cameras all over the place. They clearly had to work to make this happen. And I think that the court should sentence her on the very high end of the guidelines in this circumstance. I couldn't charge CSC 1 because it didn't meet the criteria. I tried everything to find a way to get around the different criteria. It's a juvenile justice facility owned by DHS, and that designation changes a lot of things. But everything that I came up with was he was over the age of 16, which is part of the elements for CSC 1. So I charged her, she pled, she took responsibility early, and I'd ask the court to sentence her on the high end. Thank you.
All right, thank you. Ms. Palmer, if you can come back up to the podium. Mr. Williams, anything on behalf of Ms. Palmer today?
Just a couple of things, Your Honor. The email was sent with the psychological. It did get sent to the prosecutor's office. It kept bouncing back as sure someone was out of office. I would like the court to consider that evaluation. It's a psychological evaluation done by professional psychological services in Grand Rapids. And really, it echoes the PSI that she's very low recidivism. I mean, very low. I think we'd be remiss to think that this kid is completely innocent. I think it's actually, frankly, absurd. He staged the problems. She had nothing to do with it. There's nothing in this record on film, anything, anywhere in this record to say they were in cahoots with each other to stage this. He preyed on her. He knew her routine. She spent a first part of her life in law enforcement as a female police officer in a super male dominated, ego driven type mentality / environment, which was traumatic to her, gave her very low self-esteem per her psychological evaluation, made her really question herself as a person. And and felt at a low point. She didn't have anywhere else to work, any other skills, so she got a job at this correction facility. And this person planned these things to happen with her. And the first time it occurred, she didn't fight it. It happened, and it happened, and she didn't know how to accept it. She didn't know what to do. She didn't know she should report this. She didn't know what to do. And then it happened again. And in between the first time it happened and the second time it happened, she anguished over it. She has 2 other children. She had a husband. She had no one to talk to. She felt weak. She felt inferior. And that's her story. Frankly, he's 16 years old. He's old enough to consent. He's old enough to be violent enough to physically harm people or kill someone. He's old enough to be incarcerated like an adult, and he's old enough to be incarcerated in a prison here at some point. But he's not an innocent child. He's a young man who's certainly a kid. I completely agree with everything his mother said. As a parent, I agree with her 100%. But in reality, she's not a predator. She's a tiny little person who has super low self-esteem, who barely has a cognitive ability to function, and has very poor decision-making skills. So, and she spent her life dedicating it to law enforcement and to the community and as being a corrections officer. So she made a huge mistake, but she also has 3 kids now. They have a family member here who wants, thank you, 2 kids now. A mom who has the foresight, a grandmother has the foresight that realizes that they need to patch this back together. I'm going to ask the court, and the young man did put in his written statement that he was the mastermind behind this, that he is in counseling, but it's not for this, it's for other reasons. So I'm asking the court to do a downward departure. Place her in prison puts 2 children without a mother. There's 0 likelihood for her to ever reoffend. I mean, 0 in this one. It's not going to deter another person from getting involved, another correction officer from getting involved in a unique circumstance like this. And it's only going to bring further harm to the community and to her children that are involved here. This young man wants to be part of the child that she's the mother to. They're going to be connected, whether she goes to prison or not, the rest of their lives. And so are these families. So what purpose does it really serve? And I mean that from a very practical standpoint. I'm not saying this as a defense attorney. I'm saying this has been doing this job for 20 years and some 1,000+ cases by now at least. And I'm saying, hey, we got a person who had sex with someone who, but for the working in the institution, it would have been consensual, mutual, and legal. Now there's a child born, and we have a person that's not going to reoffend. She's certainly not going to get another job at a correctional facility, and she's highly unlikely to reoffend regardless, based off of not only the scoring in the PSI and the scoring in the psychological eval. So frankly, if you gave her local services, put her in counseling and treatment and therapy, she could raise her own children in the community and not depend on other people to do that and those resources. And she can figure out how she's going to spend the rest of her life with this SORA registry and felony on her record. So that's a huge punishment. So I'm asking the court to do a downward departure. There's plenty of substantial compelling reasons to do so. She comes before the court with no criminal history. Thank you, Your Honor.
Ms. Palmer, is there anything that you wanted to say today? All right, so I read through the report. I'm obviously familiar with what happened in this case and your actions. I've heard from the victim's mother, both here on the record today, as well as writing through her impact statement, which was consistent with what she stated here. I've listened carefully to what the lawyers had to say. The court has a number of goals that it tries to achieve through sentencing. Number one is to punish the offender, in other words, to punish you for the wrongful conduct that you engaged in, to protect the community, to remove you from the community for a period of time, so that you don't have the ability to commit any offenses. Deterrence, so that other people see that this is the type of conduct that we don't condone or accept as a community or a society. And so hopefully people see that and don't engage in this kind of conduct because they understand there's consequences to it. And then finally rehabilitation. So when I look at what is an appropriate sentence in this case, I try to balance all of those factors. There's a few things that stick out to me about this case in particular. And I understand the argument. Everybody's referenced it here today that this is a young man who was 16, at least at the time of at least one of these. I think based on the prosecutor's statements, it's possible that something occurred when he was 15, but regardless, a teenage male. And everybody's alluded to the fact that he doesn't see himself as a victim in this case. But the law views him as a victim, whether he thinks he's a victim or not. And the law views you as an offender. And that's because when you have a young person who's under the age of 18, and in this case, obviously a troubled young man who's had a lot of issues in his life aside from this. A young man that I think everyone would agree doesn't have the best judgment and doesn't have the most maturity. It's your job as an adult, setting aside from the fact that you are charged with the responsibility of overseeing these individuals. If this was just something that happened out in the world, as an adult, as a grown woman, as someone who's supposed to have some maturity, certainly greater maturity than a 15 or 16-year-old boy does, it's your responsibility as an adult, even if that individual wants to engage in this conduct, to say, you know what, this isn't good for you, this isn't good for me, we're not going to do this, to exercise some better judgment. Certainly in your role at Shawano and the responsibility of oversight that you had even a greater responsibility to exercise better judgment and not allow this individual to engage in conduct. And that's assuming that he was the mastermind behind this. When I read that report, it read much more to me like this is something the two of you came up with and executed together to be able to have access to each other. So I don't accept the premise that the young man is not a victim in this case. I don't accept the premise that you were led astray and that you had no ability to resist and that he essentially convinced or forced you into this. I think you did this completely of your own accord for your own reasons to satisfy your own urges and desires, and that you did that without exercising any kind of good judgment or maturity to say no to this if you did want to do it. Setting all of that aside, you put that entire facility at risk. Every other person that works there was endangered by your conduct. Every other juvenile who was part of that was there for correctional reasons, to be helped, to be made better. You put all of those people at risk. And why? So that you could engage in sexual conduct and make yourself feel better for a little bit of time. That is conduct in and of itself. I think that warrants some serious punishment. You undermined the community and our society's ability to trust in people who are put in those kinds of positions of responsibility. To trust that when young people are sent to a facility like that, that they're going to be guided, that they're going to be looked after, that they're not going to be taken advantage of, and that the people who are charged with their care and their oversight aren't going to use that authority position to engage in their own sexual desires, which is exactly what they did. I can't imagine what was going through your mind that made you think that this was okay to do once, let alone multiple times, let alone allow yourself to become pregnant and have a child as part of this. I was unable to find any kind of logical thought process that would allow you to do that, especially given your position. So for all those reasons, I think it's necessary to impose a Department of Corrections sanction. I think it needs to be a sanction that sends to you a clear message that this is not conduct that is tolerated, to punish you for that wrongful conduct. Send a message to the community and other people working in those positions that sexual contact with juveniles that you're in charge of is not going to be tolerated or accepted. And hopefully through that sentence, rebuild some of the trust that was lost in those types of facilities and people that work there because of your actions. I do think there are some mitigating factors that Mr. Williams pointed out. You do have a lack of prior history. If you are a young person, you're 32 years old, you have an opportunity to correct your behavior going forward, and I hope that that's what happens. And I think the recommendation balances those aggravating factors that I've discussed as well as the mitigating factors. So if the court finds that a sentence within the guidelines, but towards the top end of the guidelines is appropriate, the court is going to send you to the Michigan Department of Corrections for a period of 48 months to 15 years. You do have credit for 1 day served. Court is going to require that you register under the Sex Offenders Registration Act and comply with all reporting requirements, that you not have verbal, written, electronic, or physical contact with the victim, either directly or through another person, and that you not be within 500 feet of that person's residence, school, or place of employment. The crime victim's assessment of $130, court costs of $325, DNA testing fee of $60, $68 state costs. You do have the ability to seek an appeal of the sentence. Mr. Williams, there is an acknowledgement of Ms. Palmer's appellate rights there.
Oh, okay.
If you can have her acknowledge receipt of those, Ms. Palmer, those papers are going to explain to you what your appellate rights are as well as how to.
I take
We are
one.
rescinding the testimony.
Thank you.